Hi friends, in this video we are going to deal with the case summaries of the important Supreme Court judgments pronounced in the year 2022. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Union of India and Others versus Suprada Nath pronounced on 23rd November 2022, disciplinary proceedings against respondent constable resulted in an order of his dismissal from service. The appellate and the revisional authorities upheld the said order. The respondent filed a writ petition before Calcutta High Court. The single judge set aside the punishment of dismissal and compulsorily retired respondent from service along with all consequential benefits. On appeals, the division bench reinstated the respondent along with full back wages. The disciplinary authority was further directed to issue a fresh order of punishment that should consummate to his negligence and dereliction of duty other than a punishment of dismissal, a removal from service or compulsory retirement. Being aggrieved, the present appeals have been filed with allegation that the High Court acted as appellate authority by directing a reinstatement of the respondent, which runs contrary to the law laid down in B.C. Sadurvedi versus Union of India and Others, reported in 1995, 6 SCC 749. The point that arises for consideration is whether single judge and the division bench ought to have interfered with the punishment imposed on respondent by the disciplinary authority and upheld by the appellate and the revisional authorities. The Supreme Court has held that courts ought to refrain from interfering with findings of facts recorded in a departmental inquiry, except in circumstances where such findings are patently perverse or grossly incompatible with the evidence on record. However, if principles of natural justice have been violated, or the statutory regulations have not been adhered to, or there are malefides attributable to the disciplinary authority, then the courts can certainly interfere. Being fact-finding authorities, both the disciplinary and the appellate authorities are vested with the exclusive power to examine the evidence forming part of the inquiry report. On finding the evidence to be adequate and reliable during the departmental inquiry, the disciplinary authority has the discretion to impose appropriate punishment on the delinquent employee, keeping in mind the gravity of the misconduct. However, in exercise of powers of judicial review, the High Court, or for that matter, the tribunal, cannot ordinarily reappreciate the evidence to arrive at its own conclusion in respect of the penalty imposed, unless and until the punishment imposed is so disproportionate to the offense that it would shock the conscience of the High Court or tribunal, or is found to be flawed for other reasons. The records reveal that the disciplinary authority minutely examined the entire evidence brought on record, including the deposition of 8 prosecution witnesses, each of whom corroborated the charges leveled against the respondent, duly supported by documentary and circumstantial evidence, for arriving at the conclusion that the articles of charge 1 stood proved against the respondent. Pertinently, the respondent did not produce any defense witness, and the documents produced by him did not prove anything in his favor. As for charge 2, the disciplinary authority noted the statement of PW4, who was working as in charge of the document section of the unit and was summoned to prove copies of the service documents related to the respondent, and on going through the said documentary evidence, noted that the respondent was awarded 8 punishments over a period of 13 years of service for various delinquencies, but he did not reform himself. In view of his continuous misconduct in the past, coupled with the serious offense of theft of 800 kilograms of copper wires, subject matter of charge 1, the disciplinary authority opined that the respondent was unfit to be retained in a disciplined force and therefore directed his dismissal. The findings of the disciplinary authority met with the approval of the appellate authority and the revisional authority. However, the single judge overturned the dismissal order and converted the same to compulsory retirement on the sole ground of non-availability of the original record, more specifically the bead book, while giving a go-by to the extract of the bead book that was produced before the inquiry officer and the fact that the respondent admitted this said document. The single judge also ignored the fact that the bead book was not only the piece of document produced before the inquiry officer. There were depositions of other witnesses produced by the department to prove the charges leveled against the respondent, and the said witnesses corroborated the version of the department. At no stage did the single judge observe that the departmental inquiry was vitiated on account of violation of rules of natural justice, or that the inquiry was conducted in gross violation of the statutory rules. The division bench went a step further and proceeded to reappreciate the evidence and observed that it was not persuaded to conclude that such a major theft of 800 kilograms comprising of 42 bundles of copper wires could have happened in the blink of an eyelid, despite holding that the view of the single judge regarding non-production of the original bead book was unsustainable. The court held that the allegation of connivance in the theft leveled against the respondent was presumptive, and there wasn't enough evidence to conclude that theft of such a magnitude could have happened during the duty period of the respondent alone, yet charge one pertaining to negligence and dereliction of duty on the part of the respondent was sustained. At the same time, the order passed by the single judge directing substitution of the punishment of dismissal with that of compulsory retirement was set aside, and the respondent was directed to be reinstated in service with full back wages, while giving liberty to the disciplinary authority to issue a fresh order of punishment commensurate to the negligence and dereliction of duties on his part, except for punishment of dismissal or removal from service or compulsory retirement. There was no good reason for the High Court to have entered the domain of the factual aspects relating to the evidence recorded before the inquiry officer. This was an attempt to reappreciate the evidence, which is impermissible in exercise of powers of judicial review vested under Article 226 of the Constitution. Therefore, the High Court ought not to have interfered with the findings of fact recorded by the disciplinary authority. Thus, the single judge and the division bench erred by setting aside the dismissal order. This court finds in complete agreement with the findings returned by and conclusion arrived at by the disciplinary authority, duly confirmed by the appellate authority and upheld by the revisional authority in respect of both the articles of charges leveled against the respondent and the punishment imposed on him. The respondent, being a member of the disciplined force, was expected to have discharged his duty diligently. Further, the records revealed that the respondent did not mend his ways during 13 years of service rendered by him and was awarded 8 punishments for the various delinquencies, out of which 3 punishments included stoppage of increment on 2 occasions for 1 year without cumulative effect twice, and stoppage of increment for 2 years without cumulative effect on 1 occasion. In such circumstances, the desirability of continuing the respondent in armed forces is questionable, and the disciplinary authority could not be expected to wear blinkers in respect of his past conduct while imposing the penalty of dismissal. Therefore, it is appropriate to quash and set aside the impugned judgments and orders while restoring the findings and the conclusion arrived at by the disciplinary authority, duly upheld by the appellate authority and endorsed by the revisional authority. Thus, the penalty of the dismissal imposed on respondent is commensurate with the gross negligence and dereliction of his duty.
In the important judgment titled Jagdish Prasad Saini and Others vs. State of Rajasthan and Others, pronounced on the 26th of September 2022, the Supreme Court has held that the leave encashment is part of salary. The facts of the case would be that the appellants were appointed against sanctioned posts. They continued to work uninterruptedly in that establishment on a regular basis. By a unilateral resolution, the managing committee of the establishment decided to discontinue receipt of grant in aid from the state. In the meanwhile, the state brought into force the Rajasthan Voluntary Rural Education Service Rules, 2010, with the objective of providing security to the employees working in aided institutions and to absorb them in the state's service. The appellants sought their absorption with the state in accordance with the rules. Finally, they were driven to file writ petitions before the Rajasthan High Court. The High Court held that neither gratuity nor leave encashment was covered by expression, salary, under Rule 10 of the Rajasthan Voluntary Rural Education Service Rules, 2010 or under the Rajasthan Non-Government Educational Institutions Recognition Grant in Aid and Service Conditions, Extra, Rules, 1993. Being aggrieved, present appeal has been filed. The Supreme Court has held that non-government educational institutions in Rajasthan are governed by the Rajasthan Non-Government Educational Institutions Act, 1989 and the rules framed. In the present case, the appellants had to fight for their entitlements. The state initially refused them the benefit of regularization. Their petitions for relief were unsuccessful. Ultimately, this court by its order, dated 19 July 2016, directed their regularization. The court even initiated suo motu contempt proceedings, after which the appellants were paid their salaries and arrears according to the recommendations of the Pay Commission. However, the appellants' complaint of non-compliance with the respondents' obligation to pay leave encashment and gratuity for the period they were in the aided establishment was not gone into. They were permitted to agitate that grievance before the High Court. Upon their doing so, the High Court gave short shrift to their argument, holding that since arrears of salary had been paid, nothing more was needed to be done. In State of Rajasthan and Another versus Senior Higher Secondary School, Lachmangad reported in 2005, 10 SCC 346, this court held that salary under the Act includes leave encashment. The aforementioned reasoning is binding and conclusive as regards entitlement of the appellants to claim leave encashment benefits. In the scheme of the Rajasthan Non-Government Educational Institutions Recognition Grant in Aid and Service Conditions, Extra, Rules, 1993, the assessment of, and determination of the extent of, aid to be granted to any institution, is provided by Rule 13. What forms part of the approved expenditure that would be the content of aid, is provided by Rule 14. In the present case, the management establishment was recipient of 70% aid, in the form of grant. In these circumstances, the state cannot shrug its responsibility to shoulder its part of the responsibility to pay the appellants the share of leave encashment benefits and hide behind either Rule 5, 8, or the undertaking executed by them. The appellants are held entitled to privilege leave entitlement benefits. Such benefits shall be calculated from the date they entered the service of the establishment till the date of their absorption by the state in 2016. The state shall pay the benefits due to the extent of 70% and the balance 30% shall be payable by the management establishment. Therefore, with respect to leave encashment, the state and the respondent numbers 3 to 7 are liable to pay the appellants in the ratio of 70:30 respectively. The respondent state shall, within 4 weeks from today, determine the extent of entitlement of each appellant and communicate the extent of amount payable by the management establishment to the appellants. These amounts shall be paid by all the respondents within 6 weeks from today. The respondent numbers 3 to 7 shall also calculate and pay the amount of gratuity to the appellants on the basis of their initial date of entry in the school, till the date of order of absorption by the respondent state, within 6 weeks from today. Since both sets of respondents contested their liability and denied them to the appellants, the amounts payable to the appellants shall also carry interest, at the rate of 10% from the dates of their entitlement, till the date of payment. The impugned order is therefore set aside. The appeal is allowed in terms of the above directions.
In the important judgment titled Sudesh Chikara versus Ramdi Devi and Another, pronounced on 6th December 2022, a mother from Gurugram moved the maintenance tribunal to cancel the gift deed with allegation that her children were not maintaining her. The maintenance tribunal declared the gift deed to be null and void. On appeal, the Punjab and Haryana High Court upheld the tribunal order. Being aggrieved, the present appeal has been filed. The Supreme Court has held that the Senior Citizens Act was enacted for making effective provisions for the maintenance and welfare of the parents and senior citizens guaranteed and recognized under the Constitution of India. For attracting section 23(1), the following two conditions must be fulfilled, and they are: the first one, the transfer must have been made subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor. The second one is, the transferee refuses or fails to provide such amenities and physical needs to the transferor. If both the conditions are satisfied, the transfer shall be deemed to have been made by fraud or coercion or undue influence. Such a transfer then becomes voidable at the instance of the transferor, and the tribunal gets jurisdiction to declare the transfer as void. When a senior citizen parts with his or her property by executing a gift or a release in favor of his or her near and dear ones, a condition of looking after the senior citizen is not necessarily attached to it. On the contrary, such transfers are made out of love and affection without any expectation in return. Therefore, when it is alleged that the conditions mentioned in section 23(1) are attached to a transfer, the existence of such conditions must be established before the tribunal. The petition filed under section 23 shows that it is not even pleaded that the release deed was executed subject to a condition that the transferees would provide the basic amenities and basic physical needs to respondent number 1. Even in the tribunal order, no such findings was recorded. Oral evidence was not also adduced by the parties. Immediately after a reply was filed by the appellant that the petition was fixed for arguments. Effecting transfer subject to a condition of providing the basic amenities and basic physical needs through the transferor, senior citizen is sine qua non for applicability of section 23(1). In the present case, it is not even pleaded by the respondent number 1 that the release deed was executed subject to a condition, and even in the counter filed by the respondent number 1, the same was not pleaded. It is merely pleaded that the appellant had no intention to take care of her mother. Thus, the tribunal order cannot be sustained as the twin conditions incorporated in section 23(1) were not satisfied. Unfortunately, the High Court did not adhere to the merits of the case. The tribunal order and the order passed by the High Court are hereby set aside. The petition filed by the respondent number 1 under section 23 stands dismissed.
In the important judgment of Katukandi Ithathil, Krishnan and others versus Katukandi Ithathil, Wilson and others, the judgment was pronounced on 13th June 2022. The Supreme Court has held that long cohabitation between a man and a woman raises a strong presumption in favor of their marriage. The facts of this case would be that plaintiffs who filed a petition suit contended that the sued property belonged to one Katukandi Ithathil Kankaran Vedyar, who has 4 sons: Damodaran, Achyutan, Shekharan and Narayanan. The first plaintiff is the son of Damodaran, born in the wedlock with Chiruthakutti, and the second plaintiff is the son of the first plaintiff. The defendants submitted that all the children except Achyutan died as bachelors, and Karunakaran is the only son of Achyutan. They denied the contention of plaintiffs that Damodaran married Chiruthakutti and that the first plaintiff was the son born to them in the said wedlock. The trial court found that Damodaran had a long cohabitation with Chiruthakutti, and thus it could be concluded that Damodaran married Chiruthakutti and that the first plaintiff was a son born in the said wedlock. The trial court passed a preliminary decree of partition of the sued property into 2 shares, and one such share was allotted to the plaintiffs. Allowing the appeal filed by the defendants, the High Court held that there is no evidence to establish the long cohabitation between the father and the mother of the first plaintiff, and the documents only prove that the first plaintiff is the son of Damodaran, but not a legitimate son. Beyond agreed, present appeals have been filed with the issue posed for consideration, and that is whether there is sufficient evidence to prove the long cohabitation to establish the relationship of husband and wife between Damodaran and Chiruthakutti. The Honorable Supreme Court has held that it is very well settled that if a man and a woman live together for long years as husband and wife, there would be a presumption in favor of wedlock. Such a presumption could be drawn under Section 114 of Evidence Act. Although the presumption is rebuttable, a heavy burden lies on him who seek to deprive the relationship of legal origin to prove that no marriage took place. In this evidence, prosecution witness number 1 stated that Damodaran married Chiruta Kutti. The evidence of prosecution witness number 2, who was a neighbor, also shows that the marriage between Damodaran and Chiruta Kutti was a love marriage. The plaintiffs produced birth certificate of the first plaintiff in which Damodaran and Chiruta Kutti are described as father and mother. One more important document, which is the copy of the similar certificate produced by the defendants, also shows that Damodaran and Chiruta are described as father and mother of first plaintiff. Thus, the documents on record would show that the first plaintiff is described as son of Damodaran. Further, there is also enough materials to show that Chiruta was getting some money from the family of Damodaran, including in particular the letters at documents A22 and A23, which were addressed for the first plaintiff by his mother Chiruta long back in 1976. The trial court discussed this aspect of the matter. The documents on record, coupled with the evidence of prosecution witness number 2, would show that long duration of cohabitation between Damodaran and Chiruta as husband and wife. The first plaintiff joined military service in the year 1963 and retired in the year 1979. Thereafter, he took the steps to file a suit for partition of the suit scheduled property. However, the defendants failed to rebut the presumption in favor of the marriage between Damodaran and Chiruta on account of their long cohabitation. In these circumstances, the High Court was not justified in setting aside the said judgment of the trial court. Therefore, the judgment of High Court is set aside and the judgment and decree passed by the trial court is restored.
In the important judgment titled Martin and Harris Private Limited and Others versus Rajendra Mehta and others, pronounced on 6 July 2022, the Honorable Supreme Court has held that once a decree of eviction is stayed, it is necessary for the appellate court to fix the men's profit to be paid by the tenant to the landlord for continuing the possession of the premises. The facts of the case would be that the plaintiffs, the owners of the suit property, filed a suit for eviction, possession, recovery of rent and permanent injunction. The suit was decreed and it was confirmed on appeal. The second appeal was filed challenging both the judgments before the Rajasthan High Court, which was admitted by order granting stay on ejectment. The order of stay was extended from time to time. On filing an application under Order 41 Rule 5 read with Section 151 of CPC by the plaintiffs asking for men's profit due to continuation of stay on eviction decree, it was decided, whereby the appellants were directed to pay the men's profit at rupees 2,50,000 per month from the date of filing of application till the disposal of the appeal. The said order was challenged by filing the special leave petition before the court, which was dismissed as withdrawn with liberty to the appellants to file review petition before the High Court. On filing the review petition, it was dismissed by order, which led to file the present appeals challenging the said order as well as the order passed in review questioning the grant of men's profit. The Supreme Court has held that in the previous proceedings filed under Section 6 and 7 was under the old Act, that is, Rajasthan Premises Control of Rent and Eviction Act 1950, wherein the standard rent was filed rupees 45,000 per month to the suit property. During the proceedings, the present suit seeking decree of eviction was filed by the plaintiffs under the provision of the old Act in November 2002 prior to the commencement of the new Act, that is, Rajasthan Rent Control Act 2001. Thus, on the date of commencement of the new Act, the present suit was pending and white judgment dated 3/6/2016 trial court decreed the suit, which was confirmed in appeal by the lower appellate court on 10/1/2017, challenging the judgment and decree concurrently passed by the two courts. Second appeal was filed by the appellants, which was admitted on 14/10/2017, and stay of ejectment passed by the High Court, which was extended quite a few times. Thereafter, on filing an application under Order 41 Rule 5 read with Section 151 of CPC asking men's profit by the plaintiffs, it was allowed by order dated 18/5/2018, against which the special leave petition which was filed by the appellants was dismissed as withdrawn with liberty to file a review petition after noting the submissions made before this court. On perusal of the order, it is clear that the appellants raised a plea that maximum payable men's profit as per Section 20 of New Act can be 3 times of the rent in case of premises let out for commercial purposes. It was said that the standard rent was fixed at rupees 45,000 per month, as a result of which 3 times would come to rupees 1,35,000. However, the direction of men's profit was at 2,50,000 per month by the High Court is unjust. This court, without expressing any opinion with respect to filing the quantum of men's profit, directed to approach the High Court by filing the review. Further, Section 20 of the new Act deals with the execution of the orders of the Rent Tribunal in the manner so prescribed. Subsection 3 makes it clear that if the tenant does not vacate premises within 3 months of the date of issue of certificate for recovery of possession, in that event he is liable to pay men's profit at the rate of 2 times the rent in case premises let out for the commercial purposes at the rate of 3 times the rent in case of premises let out for the commercial purposes as applicable in the facts of the present case. As per Section 32 of the new Act, the repeal and savings clause of the old Act has been specified. However, only subsection 3 is relevant, which has been given overriding effect to the other provisions by which the application or suits or other proceedings filed under the old Act pending on the date of commencement of the new Act before any court shall be continued and disposed of in accordance with the provisions of the old Act, as the old Act continued in force and this Act had not been enacted. Thus, it is clear that the suit or proceedings, if any, pending on the date of notification issued by the state for applicability of the new Act, such proceedings would continue under the old Act and new Act has no application. Therefore, the High Court rightly rejected the contention while dismissing the review petition and rightly held that Section 20 of the new Act, by which 3 times men's profit to the standard rent was made permissible for the suit or proceedings started under the new Act, have no application in suit or proceedings initiated under old Act and pending on the date of commencement of the new Act. The reasoning given in order while rejecting the review petition by the High Court is perfectly in consonance to the spirit of Section 32 of the new Act. Thus, the findings of the fact recorded by the High Court do not warrant any interference. Thus, after passing the decree of eviction, the tenancy terminates and from the said date the landlord is entitled for men's profit or compensation depriving him from the use of the premises. Therefore, looking to the fact that the decree of eviction passed by the trial court has been confirmed in appeal, against which the second appeal is pending, however, after stay on being asked the direction to pay men's profit or compensation issued by the High Court is in consonance to the law laid down by this court, which is just, equitable and reasonable. On the basis of determination of the amount of men's profit depends on the facts and circumstances of each case, considering place where the property is situated, that is, village or a city or a metropolitan city, location, nature of premises, that is, commercial or residential, and the rate of rent precedent on which premises can be let out are the guiding factors in the fact of the individual case. In the case of at hand, the High Court observed that the tenanted property is located on the main road of New Colony near Panchbati, which is a commercial area and the heart of Jaipur city. The said finding was arrived considering the voluminous documentary record dispelling the plea taken by the appellants. However, The court found it reasonable to determine rupees 2,50,000 per month as men's profit as per the discussion made herein above so far as the area of the tenanted premises and the location of the property is concerned. The findings of fact have been recorded by the High Court. Those findings are based on the material brought on record, which are neither persuasive nor illegal. The amount of men's profit as fixed before the standard rent and 6 years from the date of passing of the decree of eviction. Therefore, the amount of men's profit has rightly been decided by the High Court while passing the impugned order.